welcome to another Monday download. Today I want to talk about bankruptcy, and you'll see if you look at all of our videos that we do have several on bankruptcy. And the reason that is because bankruptcy tends to be something that you as a real estate agent dealing in the world of short sales and distressed sellers, you're going to run into it more often than not. And bankruptcy attorneys have really become aggressive in marketing to your sellers and anyone in a distressed situation, because they see that as an opportunity to grow their business. They're business people just like you and I, and sellers that are upside down or sellers that can't make their mortgage payments, to them, they're potential clients. And so they're going to market to your sellers. An interesting study that I recommend all of our real estate agents do is that when you're working with a distressed homeowner, that one of the things you ask them to do, one of the jobs you give them, is to collect all of the mail that they receive regarding their home, regarding their situation, and collect all of that and give it to you as you visit with them throughout the listing process. And what that does is give you a little bit of a bird's eye view as to what your competition is out there, who's marketing to them besides yourself in your area, whether it's other real estate agents or bankruptcy attorneys. And I'll guarantee that you're going to see something from one or two or maybe even more bankruptcy attorneys that are really aggressive in their marketing. Most often the real estate agent, you as the list agent, are earlier in the process, so as they get closer to a potential foreclosure, that's when bankruptcy attorneys start to kind of come out of the woodwork. So let's talk a little bit about bankruptcy. Ultimately, you're never wanting to give legal advice to your seller, and so you want to share with them the knowledge that you have, the information that you understand about bankruptcy and how it relates to short sales, and then recommend that they go sit down with some legal counsel to actually confirm for their situation what's best or not best for them to do. My recommendation in regard to that is to have them sit with somebody who's not a bankruptcy attorney or who doesn't specialize in bankruptcies. And the reason is because it can tend to be a bit of a conflict of interest for a bankruptcy attorney to sit down and look at the different options and be able to honestly appraise their situation and say, yeah, bankruptcy is not necessarily what you need right now, or maybe even at all, because that's a paycheck walking out the door for them. That's how they get paid and how they grow their business. If they consult with kind of a general real estate attorney, the general practitioner, if you will, that attorney is going to be able to take a little bit more of a pulled back view. That's their client that they're getting paid for with this specific session, and they're supposed to give them the best possible advice for what their situation is. So that would be my recommendation as far as legal advice, is make sure that you get somebody who's not going to be waving goodbye to $1,500 or $2,000 in order to say, no, you don't need a bankruptcy. So let's talk about timing with bankruptcy. There's basically two options for timing of bankruptcy. One is during a short sale transaction, before or during, and the other is after a short sale has been completed. So let's talk about during the short sale transaction. First of all, because you're more proactive and you're usually the first one that a seller comes to before they consider a bankruptcy, because they're trying to avoid that option, you're going to have been marketing and this property for sale. You may even have an offer that you're negotiating with the bank, and then all of a sudden the seller decides they want to file a bankruptcy. Well, what happens is immediately the bank that is negotiating the short sale shuts that file off and they stop processing it. Now the reason is because, and I say most lenders do that because not all of them do. They don't technically have to, but they don't trust the parties that are doing the negotiation of the short sale to not cross the line into something that's illegal for them to do as a debt collector when someone's in bankruptcy. And so in order to avoid the potential liability altogether, they just say, nope, until this thing is discharged, we're not going to touch it. So the next phase, if you will, is the bank waiting for a discharge. What is a discharge? The simplest way that I can put it, the discharge is the completion of the bankruptcy. It's been finished, and now they have a document from the trustee saying that their bankruptcy has been completed. After the bankruptcy is completed, the bankruptcy court sends a notice to all the creditors, the banks being one of those creditors, to let them know that the bankruptcy has been completely resolved and been discharged. Even though you may have a copy of that discharge document, we've sent those to banks and they say, great, that's great, we need to have something directly from the court trustee before we're able to do any of this or pursue any of this. So they're going to wait for that, and that's going to take several weeks, 3, sometimes 4 weeks, before the trustee gets everything out to them. They receive it in their legal department, and then move it to whatever other department they may do with that. At that point, the bank will start to look at short sale again and begin the processing. Your buyer, if you had one, is probably gone. So in essence, you're starting over from ground zero. The other thing that you have to, a hurdle that you have to jump over if a bankruptcy has been filed during the process of the short sale or even prior to the short sale, is that the title company is often going to want something that shows that the bankruptcy court is allowing the sale of this real property. The discharge is satisfactory for some title companies, but others require specific filings of certain documents. As a side note, if your seller is in the middle of a bankruptcy right now or decides to file a bankruptcy before the short sale is complete, have them specifically ask their attorney for the document that allows them to sell the property. It's in essence the trustee bring before the creditors the sale of real property, they approve it, and it comes back and say, yeah, you can sell your house. So just make sure they get that. Otherwise, the attorney has to reopen the file, charges the seller more money, and then comes back to submit this to the bank. It takes several weeks for that to happen. Actually, they don't submit it to the bank, sorry, they submit it to the bankruptcy trustee, who then does his thing with the creditors. So that's kind of the process and all of the convoluted confusion that is added to a bankruptcy or added to a short sale when a bankruptcy happens. Alright, the second option is to wait until after the short sale is completed. First of all, if the short sale is done, your seller may or may not have to file bankruptcy. And the simple reality there is that if the home or the real estate is the only thing that's causing them to have to file a bankruptcy, if the short sale has been completed, then there's no need for them to file a bankruptcy and they can just move on with life. However, they may have a lot of other debt, they may have a business that failed, and a bankruptcy is still something that they want and need to do. The great thing about waiting till the end of the short sale is that if that short sale came with any sort of rights of collections or deficiency notes specific to the seller, they can roll that into the rest of what they're doing in their bankruptcy, instead of, if it's after the bankruptcy has taken place, any new notes that the bank creates are outside of any past bankruptcy, because that note didn't exist. So that's something for them to consider as well. And again, you know, they may not have to file bankruptcy at all. So that's kind of just some insight into the bankruptcy process and why we highly encourage sellers to not file a bankruptcy in the middle of the process. We actually ask them to agree not to do that. You know, if they feel like they need to get counsel whether or not they need to file a bankruptcy now or later, do that before the listing happens, so that we all are on the same page that you're not going to file a bankruptcy after we've spent hours and hours. You as the list agent who spent hours and hours with the short sale, marketing the property, negotiating the offer, get them to agree to that up front. And we have this is kind of dear to my heart right now, because we have a file at this moment that the seller filed bankruptcy. We have an approval. We're literally ready to close in the next 2 weeks, and the agents are about to wave goodbye to a $10,000 commission. And the reason is the bankruptcy. There's certain forms and things that the title company is needing and that the bankruptcy attorney is not wanting to provide, and so all these different things are creating a problem that we may not be able to close this. So if we had avoided the bankruptcy in the first place, then we wouldn't have this issue. So beware of that, visit with your seller, make sure you're on the same page and that everything is out on the table, and then that gives you an opportunity to avoid the hassles that come along with this. So anyway, have a great week. I will see you next week, and if you have any questions either on this subject or other subjects that you're seeing on here, definitely send me an email. I'd love to answer your questions, and may you find great success in your short sales coming up. Thanks a lot. Bye.